Public Protector Advocate Busisiwe Mkhwebane has suffered 2 legal defeats in court this morning. In the first matter, Deputy Judge President Aubrey Ledwaba this morning ordered parts of the Public Protector's Bosasa report be sealed. President Ramaphosa had asked the court to conceal confidential information of donors to his ANC presidential campaign. Ramaphosa alleged that Mkhwebane had obtained the information illegally. While disappointed with the ruling, the Public Protector's office says she stands by the report. Her spokesperson, Bosasa, says the banking information was obtained from the Financial Intelligence Center and not through illegal means. Public Protector Busisiwe Mkhwebane's office says they will appeal the latest legal blow from the North Gauteng High Court in Pretoria. The court ruled against Mkhwebane and said she should personally pay 7.5% of costs for counsel of both the DA as well as CASEC. This relates to the Freda Estina Dairy Farm report, which was found invalid and set aside by the High Court early in May. This is how the judge summed up the court ruling.
The failures and dereliction of duty by the Public Protector in the Estina matter are manifold. They speak to her failure to execute her duties in terms of the Constitution and the Public Protector Act. In my view, her conduct in this matter is far worse and more lamentable than that set out in the Reserve Bank matter. At least there, her failures impacted on institutions that have the resources to fend for themselves. In this instance, her dereliction of a duty impacted on the rights of the poor and the vulnerable in society, the very people for whom her office was essentially created. They were deprived of their one chance to create a better life for themselves.
Public Protector Advocate Busisiwe Mkhwebane's spokesperson, Bosasa, says her office aims to challenge the cost order in the Estina Dairy Project matter.
The Public Protector disagrees with the outcome today, just like she disagreed with the first aspect of it earlier this year, because she believes that for one to incur personal cost orders, it should have been proven that she acted fraudulently, she acted recklessly, and that there was gross dishonesty on her part, and those have not been proven in this particular matter, which is why she's disappointed with the outcome, and she will be challenging it, just like she indicated when the first aspect of the judgment was handed down a few months back, that she would be challenging this particular outcome because she fundamentally disagrees with it.
We know that the Constitutional Court has found against her in the Reserve Bank judgment, and the cost order was upheld there. So does she have confidence, or does she have any legal leeway to stand on to challenge this finding against her? Because the judge, particularly in this case, said that her conduct here in this Freda Dairy Farm matter was far worse than the Reserve Bank matter.
Well, each case is dealt with in terms of its own merits, so we cannot look at what was the state of play in relation to the Bangkok matter and want to apply those things here. So the Public Protector, as I said, does not agree with the outcome of this judgment, because if you study it, you will not find any establishment that she acted fraudulently, recklessly, and she was involved in gross dishonesty. Those standards have not been proven.
The